My first point, point A is, the point is stated like this. The interdict on the speaker as per Navam Revia is for a very finite, limited period and is needed to ensure the speaker cannot tilt the voting membership of the House. For this, the analysis I am proposing before your lordships is this. Rule 11 is said.
It is 14 days, if you really look.
No, I'm saying something else. Please turn over the page, just see this. Kindly turn to page 2, just see my analysis if it appeals to you. On Rule 11.
In A, you have said exactly what I said. The interdict is 14 days.
The interdict is 14 days.
After 14 days,
yes,
that 14-day period, the speaker cannot curtail by saying that, look, it was for my benefit.
That's correct.
Period is also for the members to gather these.
Well, the reason I'm saying.
After 14 days,
yes,
the rule says as soon as maybe.
As soon as
you can convene it on the second day.
Correct.
Once leave is granted, he has not more than 7 days.
That's right.
He can convene it on the next day. So essentially, what Nabam means is that for 14 days after the notice to remove is issued to him, he cannot then preside over the motion.
Your lordship.
So the period really, when he is disqualified, we'll say disabled.
Disabled. Is 14 days.
14 and...
now, just to add to what your lordships have said, in that 14 days, one of the arguments of the other side was, what if a member does not move a resolution after that 14 days? I wanted to take care of that argument.
What is your answer?
Which is why para 2 may be kindly seen. This is the summary of Rule 11 of the Maharashtra rules, and the Lok Sabha rules are identical. Please see, now I am placing A to E. The motion to remove a speaker requires a period of at least 14 days. Your lordships have said so. Now B. After the expiry of the period, the notice is read to the assembly by the speaker as soon as may be after the expiry of notice period. At this stage, there is no second notice or resolution contemplated to be moved by the member. Then the speaker requests for 29 members to rise. So I am saying that the member who has moved the resolution cannot delay the voting on the motion or leave being granted at all. Now please see how the speaker is further protected. Lord. Please come to para Roman 4 of my note at page 2 again. Here I have set out Rule 45 of the Assembly rules. Again, Lok Sabha is identical. Please see the rule. Subject to provisions of Rule 109, a motion shall not raise a question substantially identical with one on which the House has given a decision in the same session. So you cannot have repeated motions to interdict the speaker or to disable the speaker. So it is only 14 days in the session itself. Now, please see 109, which is the next rule I have quoted. Roman 6. When a resolution has been moved and voted upon, no resolution or amendment raising substantially the same question shall be moved within 1 year from the date of voting upon the earlier resolution. So for 1 year, the speaker has no problem. So it is actually just that 14 days for once in a year at best. If it reaches the stage of voting, and if it does not reach the stage of voting, only 14 days, a member cannot stop it at all. It's outside the hands of the member. Now, my lords, kindly see, now I'm just reading for your lordship's convenience, para 7, which is my submission. Thus, if a resolution is moved and voted upon, no resolution dealing with the same question is permitted to be moved within 1 year from the date of voting upon the earlier resolution.
That's the protection, that you can't keep on repeatedly moving that.
So that is one part of it. Now, my lord, now also consider one further argument. Suppose it is moved on the last day of the session.
It lapses.
It immediately lapses under Rule 20. I've said so at Roman 9.
Rule 20 we saw yesterday.
Yes. Now, my lord, I have also quoted for your lordship's convenience identical rules of the Lok Sabha, which say the same thing. Now, Lord, I'll just add to one more. My second point, Lord, is, which has already been argued, that by deciding vacancies, what is happening, the speaker is deciding vacancies, and the people who vote for him is total membership minus vacancies. My Lord, on reading Article 190, which I suppose your lordship would have seen also, apart from 191, 190 of the Constitution is vacancies, which refers to a vacancy created by disqualification. And the people who are voting for the speaker or not voting are total membership minus vacancies.
All right.
And lastly, I'll just
end,
I'll just end with one last point.
Yes.
Just in addition to this, if your lordship, since your lordships have read Navam Revia in great detail, your lordship will find that what pervades the reasoning of Justice Mishra particularly is actually constitutional morality as well, which is my point C. So, my lord, at that time, Manoj Narula was the law which he cited. Thereafter, Institute of Delhi, etc. is coming. So, a constitutional functionary, namely the speaker, cannot act in a manner which is against the spirit of the Constitution.
Thank you.
This is my third.
Thank you, Mr. Bhattacharya. Yes, Mr. Zibal.
I won't take long, Melissa.